So hi everyone. Thanks again for joining. My name is Shirley, she, her pronouns. I'm with the Asian Pacific Institute on Gender-Based Violence, and here with me is my colleague Grace, our Director of Policy, who will be presenting all the information on the webinar today. I think a lot of you probably don't need any introduction to Grace. I'm going to pass it over to her very quickly after a little bit of housekeeping. So we are recording the webinar, and it will be available on our website for later viewing. So feel free, once we share that link, to pass it around to all your colleagues. We also have captioning, live captioning today. Just wait a couple of moments for it to finish being set up, but it should be working in live very soon. Let me know if you have any questions about the captions, and if they're not appearing for you and that sort of thing. Throughout the webinar, if you have any questions for Grace, put them in the Q&A box. That'll help us keep organized a little bit better, and we will leave some time at the end to answer those questions. And then if you have any technical issues, things like that, feel free to send me a message. I'll be in the background today providing admin support. Grace. That is it from me. I'm just going to go ahead and pass it over to Grace, who she can do a fuller introduction to the topic, maybe to the Institute. And so take it away, Grace.
Okay, so, and I'm gonna wait for you to put the slideshow up. So there should be a slide, just, a general title slide. Okay, thank you, Shirley. Hi, everybody. I'm Grace Wong. I'm the Director of Policy at the Asian Pacific Institute on Gender-Based Violence. And thank you to Shirley for helping me with the slideshow, because I really still have never figured out how to be able to do that and do a presentation at the same time. So, so what we are covering today, let me go back. The Asian Pacific Institute on Gender-Based Violence, for those of you who are not familiar, is a federally funded resource center on domestic violence primarily, but we also address other forms of gender-based violence, including sexual violence and human trafficking in the Asian American, and Pacific Islander communities in the U.S. and across Pacific territories. And part of one of the projects that we have at the Institute, so that folks are familiar, we collaborate with our colleagues, Esperanza United, Tahari Justice Center, and Assista Immigration Assistance on the Alliance for Immigrant Survivors, where we focus on immigration policies that impact survivors of domestic and sexual violence. So I'll be talking a little bit more about AIS in a little bit, but just wanted to give you a little bit of background about our organization and some of the work we do. We also have projects on language access and research, et cetera, and do technical assistance and training as it relates to serving immigrant AAPI survivors. So what we're talking about today is public charge. And I know there's been a lot of change and a lot of publicity about this topic in the news over the last 5 years or so. And so I just wanted, this webinar today is a explainer about the new published rule that should be finalized on taking effect in December. And Shirley, can you advance the slide? To give you a sense of what we'll be talking about, I'm going to be talking about the larger context of where this rule fits in and its impact on immigrant communities generally, and then on survivors specifically. I'm going to be explaining what public charge actually means, when it comes up for people, and then how we can be talking about public charge with survivors and their families, and then specifically like what's going on with what the former rule was and what will be happening with the public charge rule. So next slide, please. So generally, what's happening with the public charge rule overall. During the last administration, DHS had published a final rule that greatly expanded the definition of public charge and changed the kinds of public benefits that would be considered in its determination. They also had changed, how, given a more expansive definition of how certain factors would be weighed in considering how public charge would be examined, how it would be evaluated and looking at a person's situation. And so there were a bunch of lawsuits that were filed challenging that 2019 rule that had been trying to stop implementation of the last rule. But what happened was as the litigation was ongoing, the pauses in the rule that were put in place by courts were overturned by the Supreme Court, but the actual litigation about the legality of the rule was still ongoing. And so one court, district court in Chicago specifically, had said that the last rule in 2019 had violated federal law. And, that decision or that finding was appealed to the Seventh Circuit Court of Appeals. What happened in March of 2021 when the new administration came in is that the administration asked, through its lawyers, for the appeal of that lower court's decision to be dismissed, meaning that the lower court's finding that the 2019 rule violated law means that went into effect. And so what happened then was the old policy way before the last administration that had been in place since 1999 has been in effect since then. And so what happened then was that under the new administration, they had put out, some notices of public rulemaking, and they finally, got a lot of comments. Many of you signed on to comments that others had been organizing, asking for as generous of a public charge rule as possible, especially as it relates to survivors of domestic and sexual violence, in order to, better further the purposes of many of our other laws that protect survivors. And so they issued a new rule that was published on September 9th of 2022. The rule says that will take effect December 23rd of 2022, meaning that the new rule that I'm going to be talking about today applies to applications that are postmarked after December 22nd, or excuse me, December 23rd, 2022 or after. So like people that are waiting to file, right, if they were to file right now, the 1999 guidance would be in effect. And then if they file after December 22nd, the new rule will be in effect. And it may or may not impact your individual cases. And so it may make a difference. But for most part, it shouldn't make a huge difference. And we'll talk about some of those nuances as we go along. So next slide. So anyway, I don't actually have a slide. Before I go any further, it occurs to me that I haven't actually explained what public charge, how it's defined or what it is. So the public charge, what it means is that the rule defines somebody as likely to become as a public charge if they're likely to become primarily dependent on the government for sustenance, for support after they've been admitted. And so here, let me actually look at the read out the definition specifically to you so that you've got how they've stated how they've defined it in particular. Have they actually said? So how they've defined it in the rule, it says, the definition of likely at any time to become a public charge means somebody who's likely at any time to become primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or long-term institutionalization at government expense. So we'll dive into that, but really, the definition, they don't actually define the two words public charge, but really they define this whole phrase of likely to become a public charge, which is in the law. And what it means is that somebody, the public charge concept is a basis to deny somebody admission to the United States. So it means that it comes up in the context of when somebody is applying for status, and the agency has to look at whether that person's admissible, and public charge is a ground of inadmissibility for which there are exceptions and waivers, and we'll talk about that in a minute. But overall, the new rule, as well as the 1999 guidance that's in effect, it reminds us that the public charge assessment is forward-looking. The definition talks about if they're likely to become dependent on the government or rely on cash or long-term care in the future. So when somebody's seeking to enter the United States on a visa, like they go to the consulate, they do an interview, and one of the things that the consular officer is looking at is whether they're likely to become a public charge, and that would be under a State Department rule. And then, or if they're in the US and they're applying to get their green card or their permanent residence, it's assessed at that time. The immigration officer is going to look at them and see, are you likely, if we issue you a green card or permanent residency, are you likely to become primarily dependent on cash, government assistance as it relates to cash or long-term care. And so the statute, the law itself, talks about that assessment needs to be made looking at the totality of circumstances, and the law requires that the examiner look at the person's age and their health, their family status, how many people are in the family, et cetera, whether they have a partner, whether there's others that can support them, et cetera. Look at their financial status, like their employment history or their resources that are available to them, et cetera, education and skills, and whether there's an affidavit of support from a sponsor that says, that they will support that person as they obtain their residency, et cetera. And so looking at that totality of the circumstances test, there's no one factor, including accessing public benefits, can determine alone whether somebody's a public charge. And so they're supposed to be looking at positive factors and negative factors in making that determination. So next slide, please. So as I mentioned earlier, I want to make this super clear. The public charge test applies when the person's seeking to enter the US with a visa, and this includes for those of you working with, those on non-immigrant visas, for example, who are seeking to change their status, or maybe, they're seeking to extend their non-immigrant visa. It applies when somebody's seeking admission. And so at the green card determination, or when they're wanting to enter the United States. It does not apply, and we get this question a lot, when people are applying for citizenship. It's not a ground to deny somebody US citizenship. And so people that already have permanent residence who are applying to get US citizenship, they don't have to worry about whether they've accessed public benefits, since they've already gotten their permanent residence. And it doesn't apply to family members who are not seeking residency. So, for example, this question also comes up a lot in families where you've got mixed status families. and you've got U.S. citizen kids maybe, and they're applying, they get public benefits and food assistance and maybe TANF, et cetera. All those other family members, it doesn't matter if they are not applying for any kind of immigration status, they're not seeking permanent residence. It's only the person who is seeking status does the test apply to them. And it doesn't apply to a list of categories of people that have certain immigration status, which I'll talk about in a second. There's quite a long list. Next slide, please. So we're going to go into some of the technical aspects of this rule. And I apologize now that I might get super weedy in the rules, but we always get a lot of questions about very specific situations. And so I do want to flag for this if you have questions as I talk about this. I encourage you to put the questions in the Q&A box. You may want to be careful. Please be careful as if you're asking those questions to not include any personal identifying information about specific survivors. And know that as I go along through the slides that I may, or through the presentation, I may be answering your questions. So if I don't answer immediately, it probably means that I will be getting to the topic. So next slide, please. Oh, okay. Oh, just keep going. Sorry, this is one of those things where it slides in, and I talked about this. One more. Yep, there we go. So, definition of likely at any time to become a public charge. So I mentioned this earlier. So it's likely at any time to become primarily dependent. So primarily dependent on the government for subsistence, as demonstrated by either the receipt of public cash assistance for income maintenance or long-term institutionalization at government expense. So one of the, so we're going to go through some of these bit by bit. Next slide, please. Well, first of all, primarily dependent. It means, as we're talking about primarily dependent, it means if you got some of these benefits for a short amount of time or it's only a sliver of part of your income, for example, if you have other jobs or other income and you received any of these benefits for a short amount of time, that's going to be taken into account. And so the question is, of course, is that likely to happen in the long term in the future if you're admitted? And so just remember, it's a forward-facing test. But we're going to go into the particular types of benefits. Ongoing, so public cash assistance for income maintenance, it speaks to ongoing funds intended to pay for basic living expenses. And so, this includes supplemental security income, so SSI, for those who are disabled, or temporary assistance for needy families. TANF is another one. And then state and local government cash assistance for income maintenance, such as general assistance, these are programs that are based on income. So, earned benefits that people have because, for example, unemployment that you paid into the unemployment system, or let's see here, childcare assistance, emergency assistance. A lot of states and local governments had put together emergency, benefits as a result of the pandemic that were related to the public health emergency. So those kind of short-term emergency type benefits don't count. For those of you that are working with folks in Florida right now who have experienced the hurricane, et cetera, like emergency type benefits out of FEMA, those kind of benefits are not included ongoing funds that are intended to be income maintenance. So let's see here. So these are, intended ongoing government funds intended to pay basic living expenses. And so, next slide, please. Then there's also the other thing is long-term institutionalization at government expense. And I'm going to encourage you all to put stuff in Q&A because stuff like I can see, stuff flashing up on my chat, but chat is harder to keep track of because it just is a long string. And so let's see here. Long-term institutionalization at government expense includes Medicaid-funded long-term institutionalization or state or locally funded long-term institutionalization. And it doesn't include home and community-based services or short-term rehabilitative care, and doesn't include any other kind of Medicaid benefits. And it doesn't include incarceration for criminal grounds. And so we know that, so in this, like, state funded Medicaid expansion dollars that are used for institutional care is, could possibly be considered. The rule does talk about, though, so that people are clear, that disability alone, so somebody who's disabled, who has a disability and needs, supportive care, if it's not institutionalization, disability alone is insufficient evidence that somebody's likely to become a public charge. That one of the things that the rule does talk about that's interesting to know is that they will consider evidence that institutionalization that violates federal law. They'll consider that in evaluating the totality of the circumstances. For example, in some states, there aren't a lot of services for in-home care, community-based and home-based services. And so there are states in which, a lot of folks get put into institutional care because there isn't the availability of home and community-based services. And so what the rule says is they will evaluate that because that's actually a violation of Medicaid rules. And so that's, an ongoing issue in some of those states. But I just want to flag for you that if people are institutionalized because they haven't exhausted or haven't given people the option of having other home and community-based services, that is something that the agency will take into consideration. Let's see here. And then next slide, please. The rule is really, very specific about what it means to receive public benefits. It speaks to when the person in themselves who's applying for immigration status or seeking admission is listed as the actual beneficiary. So it doesn't include the kids. So we see this a lot with survivors. They've applied for TANF for their children, but they are not the actual beneficiary because it's the children who are eligible and they are not. And then it counts, at the time of actually, currently receiving the benefits or having received it in the past, meaning like just because somebody's applied and they, might be eligible for it in the future because, they might be low income or there might be, they might qualify because they're disabled or whatever. If they, just the potential of being able to receive benefits doesn't mean that you have actually received it. So also, I listed these. Applying for doing the application for somebody else, just submitting an application also doesn't count as having received benefits. And so just because you've applied doesn't mean, but you never actually got the benefit. And, perhaps you were denied, for example, that wouldn't qualify as receipt of public benefits and being approved even, but not having actually gotten the benefit, means that you haven't received those benefits. So, as it relates to, if somebody is eligible for, SSI or a general assistance program for low-income individuals, and they actually get the checks or they actually receive the institutional care, that's when it counts as receipts. So next slide, please. Sorry. Go ahead and just click through, Shirley. So in terms of even if somebody has received benefits, the receipt of benefits in the past and current receipt of benefits has to be considered in the totality of circumstances test. So, they have to, under the law, consider age, health, family status, assets, resources, financial status. These are the things that they're required to look at in the law, but none of those factors by itself can determine whether somebody's going to be, determined to be likely to become a public charge. And so current or past receipts alone is not enough. And then, a finding of disability is not enough. And so just want to flag this for folks that as you're working with survivors, one of the interesting things, of course, is, part of the purpose of many of our programs is to help survivors, be able to become independent, to help them get back on their feet. And so to the extent that survivors are taking advantage of different, programs that you're working with them on, whether it be job training or English as a second language skills, or, helping them, become stable, and all of those things would be, things that the Immigration Service would want to be looking at, and, in evaluating somebody's education skills, or, whatever resources that your programs have helped support, the person through as they've accessed your services that don't count in a public charge determination. Those are things that might be positive in terms of the evaluation as the agency's looking at trying to make a decision about whether that person's likely in the future to become primarily dependent on, cash assistance or institutional care. Also, just want to flag, a question that I know I've gotten as I've done this training for folks in person. People have asked whether, if somebody's applied for fee waivers in the past, for immigration status, for example, they might have asked for a fee waiver to get their work authorization, et cetera. I want to clarify that in itself, a fee waiver is not a benefit that is included in the public charge determination, though they could possibly consider it as they're evaluating the person's resources or assets or whatever. But, if, for example, they're asking for a fee waiver for a work authorization, the history of work is actually helpful at the same time. So I know that is something that people keep in mind if they have to ask for a fee waiver or not. And just, it's a possibility. I'm not going to say they shouldn't if it's really important, if they really need it. And but it is something that the service could possibly look at in the future. Okay, next slide, please. So what we are doing now as part of our administrative advocacy through the Alliance for Immigrant Survivors and in other avenues is working with the agency, USAS, to try to influence the manual for adjudicators. And so, one of the things, of course, we hope that they will include in their guidance to adjudicators, and we'll be advocating for this, is making sure that they consider somebody's need for benefits, for example, to overcome domestic violence or sexual assault, their use of how, the law itself, even under federal welfare law, provides particular exemptions for survivors of domestic violence. And so one of the things we hope, at least in the TANF context, for example, we hope that will make its way into the guidance. But we're going to be waiting for guidance specifically from USCIS about that whole totality of circumstances assessment, and hopefully we'll be able to influence it in a positive way to support survivors in getting the resources they need when they need them. And so, one nice thing about this rule, at least, is that use of other benefits like HUD benefits, housing benefits, food assistance, Medicaid, those kinds of benefits are not included in the consideration, and shouldn't be part of the test receipt of those benefits. And so, we want to encourage folks to access those as they need them. Also, if they deny people their immigration status based on public charge reasons, they have to issue a written denial that articulates how all the different factors that are included in the totality of circumstances test, and explain how they made those decisions. And so, to the extent that if they deny a case based on one of those elements, then potentially they the person might be able to get attorney to explain how that determination was incorrect or whatever. So, at least, they're required to spell out the specific basis for which they issued a written denial. Okay. So next slide. Let's see here. So as I mentioned earlier, there are some groups of people who are just exempt altogether from the public charge rule, and so they shouldn't be worrying about this ever applying to them. And so, some of these categories include refugees, asylees, Amerasian immigrants, and this speaks both at the time they enter the U.S. Or are coming in, as it speaks to refugees, in particular Amerasians. Asylees are usually already here, and at the time that they're adjusting, getting their green card. So both at the time they first get approved their application, for an asylum applicant, and when they're adjusting their status to become a permanent resident. This is true also of VAWA self-petitioners, applicants under VAWA, and those who've received, been approved VAWA self-petitions are also exempt from the rule. So this next category, and this is where I'm hoping for ongoing communication with all of you as we go on. The federal law exempts certain people who've been battered or subjected to extreme cruelty by a U.S. citizen or permanent resident, spouse, or parent. So these are people who would be eligible to apply under VAWA for status. So they would be eligible to self-petition, but choose not to self-petition. And there are lots of survivors who do that because, for example, they might not want to do a VAWA self-petition. They just want to go through the process that their spouse started for them, or their parent started for them. And so these folks are also exempt from the public charge rule. And the question I have that I'm hoping that you all will help me track, and this is one of those areas where we've got ongoing communications with the administration about how you do guidance in this context, because these are cases that may pop up that aren't clear to an adjudicator when they're looking at the person in front of them. These are folks that are eligible for federal public benefits, other than the 5-year bar piece, but they're eligible for federal public benefits because they're qualified aliens under immigration law. And so if they've been battered or subjected to extreme cruelty by their U.S. citizen or permanent resident, spouse, or parent. And I will say this, that I know that a lot of benefits granting agencies are unaware. And this very question that we have from the anonymous attendee who's asking about a client who's submitted a VAWA application and is applying for California food assistance. And I can't speak to California specific food assistance, but this person might be in this category of, if they have a prima facie, like they should have gotten, if they've applied for VAWA, usually what the agency will do was return a letter and say that they are they have submitted a prima facie application, and that person would be considered a qualified individual under federal law. And so potentially they, depending on, I'm not as familiar with California's food assistance program and what the rules are, but they would be considered a qualified individual under federal law, and so potentially eligible for the range of federal benefits. Maybe follow up with me, offline afterwards, and we can go through the specifics. Other groups of individuals who are exempt. Okay, so if benefits were asked for while, so the issue with this group of folks is that once a VAWA I-360 has been filed, there should be a notice that comes back, that there should be a receipt notice, and then potentially, if they have established all the elements that are necessary to get, there's been a review of the case and the person's gotten a bona fide determination from the agency that says that they appear to have a bona fide VAWA case, they should have gotten a notice from the administration, and that would establish that they are eligible, they're a qualified individual for federal public benefits. And so, not knowing enough, like I'm not going to ask about the specifics of your case when we can talk about that separately offline, but an individual that has that bona fide determination, or excuse me, not bona fide, the word is prima facie determination, excuse me. If they've gotten a prima facie determination notice from the agency, they are qualified individuals for federal benefits. And so, they might be subject to the 5-year bar unless you don't have that in your state. And so it depends on the state program. And so I'll need to go into that separately with you. But the prima facie determination actually will make it so, this is an exempt person under the public charge rule. So any of those benefits that they receive, they're not subject to public charge. And in the future, if they go to apply for their green card, they shouldn't be subject to the public charge rule. And so that, we're going to talk about specifically, where I'm going to go back to talk about public charge, and we can talk about benefits eligibility separately. Also, applicants for U visas, people, and those with this is where the term bona fide determination comes in. Applicants for U visas and people who've been granted U visas are exempt from the public charge rule, assuming that when they go, for example, to apply for their permanent residence, they still have valid U visa status. And so this means, like, if their U visa status has expired, maybe they're applying for adjustment of status a while later, like depending on, if they're still in good, if they still have a U visa status, they are exempt from the public charge rule when they go to apply to get their green card. But people who are just applying at the point of, so petitioners for U visas and people being, the U visa determination doesn't have a public charge determination at that particular time. Folks who have special immigrant juvenile status are exempt from public charge. And same thing as with U visas, petitioners for T visas and folks that have pending T visa applications, or those who have a valid T visa when filing to adjust status and add adjudication time are exempt from the public charge rule. And, I note these specific, like it's really specific as it relates to these statuses, because sometimes somebody has a U visa, right? And they decide, they might also have an employer who's sponsoring them, and, or, so they're going through that path. And at that particular time, they, if they still have their U visa status and they're still in good they still have that U visa status. It is, they are going to be exempt at that particular moment in time. So, but, if they no longer have it and they're, going through another path, the public charge rule may apply to them. Okay, next slide, please. I'm not going to read all of these, but, these are very current. Some of these categories are very current right now. People that are seeking temporary protected status, or Afghan, Iraqi interpreters, some of these other categories. These folks are also exempt from the public charge determination. Next rule, or next page, sorry. Next slide, I mean. And more categories of non-citizens that are eligible for status without and are also exempt from the public charge determination. And most of these folks will know that they're in a particular unique program that was created by Congress at a certain period of time. And so these are really specific immigration programs, all of these. For people from certain countries that came between a certain period of time and a certain period of time. And so when, these phrases that say certain nationals of these countries, or certain Polish and Hungarian parolees, or certain Syrians, it's like these were unique programs that were time limited, that people entered at a particular time. And so those folks are going to know that they have that unique status that was there for their country at a particular time. And so if they're applying to adjust status, or they're being paroled in, they are exempt from public charge. So next slide. Okay, so we're going to work through some examples about, what do we tell immigrant survivors and their families? Next slide. How does this rule work? So here's a couple examples of how the rule works. And these are, examples of people that we've heard about as this rule is being implemented. The first, I'm not going to read all of these to you, but the first one, I just got my asylum status a few months ago. Can I get COVID tests and vaccines, or will it stop me from getting my green card? Another person asks, I'm pregnant. I need help. I'm currently enrolled in Medicaid, for pregnant women, but I'm afraid that that'll be used against me when I go in the future to get my status. I lost my job because my employer went out of business during the COVID closures. Can I get cash grants that the city is providing for immigrants? If I apply for unemployment, will it hurt my green card application? This next one I heard a lot about. During the last administration, I heard of so many survivors turning away domestic violence, transitional housing, because they were concerned about immigration status. So, this one, I'm worried if I use transitional housing at the domestic violence program, I might hurt my immigration status. I'm on a student visa. I was raped after a university event. I'm worried that if I go to a hospital, that using healthcare might impact my visa. Or I don't have status, but I receive cash benefits for my kids. Should I disenroll them so it doesn't hurt my chances for a green card? These are all examples taken from real life that we got during the last administration. And so let's go on to the next slide as to how it plays out. Next slide. Okay, so I was just granted asylum status a few months ago. Can I get COVID tests and vaccines, or will it stop me from getting my green card? Let people know the public charge test does not apply to asylees, first of all. Second of all, COVID-related benefits, especially medical-related, healthcare, will not impact somebody getting their green card. So, there's a couple of reasons that public charge doesn't apply to this scenario or this specific question. Next question. I'm pregnant and I need help. I'm currently enrolled in Medicaid, but I'm afraid it'll be used against me. So yes, the public charge test does not consider Medicaid. It doesn't include state-funded medical benefits either. We encourage you to get the health care that you and your baby need. Okay, next one. I lost my job because my employer went out of business during the COVID closures. Can I accept cash grants the city is giving to immigrants? If I apply for unemployment, will it hurt my green card application? This one, comes up a lot. The public charge test does not apply to benefits that are not cash assistance for income maintenance. So, and the rule itself, the preamble says that special purpose public health emergency assistance and earned cash benefits like unemployment compensation would not be considered, assistance for income maintenance purposes. And so just want to flag that for you all, that people should feel free to accept those short-term special types of benefits that aren't considered, cash, like income maintenance type programs. And I know that there was a lot of work done I worked with a couple cities and communities, and others worked with, various states to create, design some of these emergency type programs for immigrant communities, whether it be through the city or state. I know there was a lot of care that went into putting together a lot of these programs for specifically for immigrant communities, so that the public charge rule shouldn't apply. Next slide, please. Okay, the domestic violence program has an opening in their transitional housing. I'm worried if I use it, it might hurt my immigration status. So housing victim services are not considered cash assistance from income maintenance. They're not considered institutionalization, so should not be considered in a public charge determination. Whoops, I should say determination, not maintenance at the end. Yes, so encourage folks to access those programs. I will say that for those of you looking, we know that HUD has also issued, has been doing some outreach with USCIS to mention that their programs are not covered by the public charge rule. We are working with federal agencies to make sure that they're developing materials in various languages to be able to do outreach and information, give information out to the communities. And so this is just one of those areas of work that, should be on the lookout for, in terms of, if you're working with clients that have these kinds of questions. I know that the agencies are developing materials, and, if they're not ready yet, they hopefully will be by the time this rule goes into effect in December. So there's that. So I'm on a student visa, and I was raped after a university event. I am worried that if I go to the hospital, that using healthcare might impact my visa. And this is, one of those cases that we heard about during the last administration that hurt my heart, really hurt my heart, that, survivor was afraid to go get a sexual assault exam done because they didn't want free healthcare because they were worried about public charge. It didn't, and that it wouldn't have impacted her at that time. And it's certainly under this new rule, it definitely doesn't. It's not, it wouldn't be considered in a public charge test. So use of medical services, free counseling would not be considered in a public charge assessment. And then next slide, or not yet, excuse me, sorry, go back. I didn't finish the last one. I have a pending U visa. I've received state cash assistance for me and my U.S. citizen kids who are citizens, sorry. Should I disenroll so it doesn't hurt my chances for a green card? So first of all, the public charge test does not apply to U.S. citizens. In addition, the public charge test doesn't apply to U visa applicants or U visa holders. So if in cases where the parent's not in an exempt status anymore, DHS will have to consider looking forward whether the applicant's likely to become primarily dependent on the U.S. government. So even if somebody has used cash assistance from income maintenance, they have to look at the totality of the circumstances. But first of all, if this person's a U visa applicant, they're exempt, so they're exempt. But also, if it's pending, they've applied, they're an applicant. When they go to, to make a decision on the U visa, public charge doesn't apply to that. So it's only in the long future after their U visas application's been approved. 3 years later, they can apply to become a permanent resident. And if they are not in U visa status at the time that they are going to get their permanent residence, then the public charge test may apply at that time. And so, you know, just a flag that for in the long term, reminding people to apply if they want to get their green card, apply for their permanent residence while they're in status, while they're in U visa status, as opposed to, you know, hopefully not doing it, you know, too late or later, because then potentially the public charge rule could apply to them. Have a question. Whether crime victim compensation would become considered under public charge. No, it would not. Crime victims comp is one of those that would not be considered. I mean, it's compensation. It's not dependent on your income. It's something that is, you know, a benefit that's provided after you've been victimized. And generally it's time limited, if I understand right. And that would not be a public charge. It would not be considered in a public charge determination. Next slide, please. Okay, so here we are. So what's happening now is they've issued the final rule as of December, that goes into effect December 23rd, 2022. It should be going into effect. We fully expect that as soon as the rule goes into effect, that there is likely to be litigation filed challenging it. And so it'll be a big question as to whether or not, you know, a federal court chooses to pause the rule going into effect or not. The good thing is that right now the status quo is the 1999 guidance, which is not as clear as the final rule that's being issued here. And I think in some ways the final rule, I mean, it builds on the 1999 guidance that's in effect that says, you know, it's a forward-facing test. They have to look at the totality of the circumstances. And so for the most part, the final rule that's going into effect in December is just reinforcing the 1999 guidance that's in effect now and strengthens a few places. And so for the most part, if the final rule is enjoined, you know, we have this ongoing guidance that's going on right now. And so the big question will be if and when a state decides, or, you know, a plaintiff decides to challenge this potential rule, or this final rule, excuse me, we don't know what the federal courts are going to do about, you know, pausing this rule going into effect or not. So that is left to be seen in our federal courts. But we know that the administration went through multiple processes. They did a notice of public rulemaking. They did an advance notice of public rulemaking, and then they issued, you know, a notice of public rulemaking, and they took all of those comments and they, you know, decided, you know, here, go ahead and pull the slides down. Whoops, this was, okay. This, they chose to go through the 3-step process. I mean, they normally, you know, you don't need to do an advance notice of public rulemaking, but they did do that. And so they solicited comments. Those were due April of this year. And, you know, they issued, after that, the notice of advance rulemaking based on the set of comments there, then they issued another notice of proposed rulemaking, and then they received hundreds of comments on that and responded specifically to all the comments that they received. And so when they issued the final rule, at least there shouldn't be viable challenges to the rule based on having violated, federal law as it relates to administrative rulemaking, which is what the challenges were during the last administration. So, yeah, there in terms of, we'll just have to wait and see what happens, but know right now that the 1999 guidance, which is similar, not as specific as the final rule, is in effect. So next slide, please. So I just want to go through some of the places where you can find the specific responses from our both the agency itself and some of our partners. So USCIS, they have a whole page specifically about public charge. So if people are looking for resources that come from the agency themselves to help reassure clients and survivors about receipt of benefits, there are public resources there. If you actually want to read the 168 pages of the regulation, I've given you a link to the final rule there. There is also the Protecting Immigrant Families campaign, which is led by the National Immigration Law Center and the Center for Law and Social Policy. And many of you, I know, participate in many of their work groups, the PIF Coalition. They've got lots of resources that are being updated, including, in-language materials as it relates to public charge. We're working with them on some Q&A documents that, like specifically speak to some of the survivor specific immigration categories. We also have a webpage on Alliance for Immigrant Survivors for those of you who are interested in continuing to be updated and engaged on policy issues as it relates to immigrant survivors. And then we have this specific advisory, this updated advisory on our website about the impact specifically on survivors, immigrant survivors of domestic and sexual violence. So those are some of the resources that are available out there. And yes, let's see here. And let me see if I have any more questions to respond to. If you have any questions, go ahead and put them in the Q&A. It looks like there is one in the chat. That says the test will not consider Medicaid, but would it consider Medicaid if it was long-term institutionalization? And the answer to that is yes. And so yes, Medicaid funded long-term institutionalization is something that the agency will consider in a totality of circumstances if it's for a long-term institutionalization. And so in those particular circumstances, that is, if that is the primary source or only source of payment for that institutionalization, yes, that's something that could be considered. And just in those situations, it's challenging, I know, but those are the ones that, folks will want to think about how to get other, I mean, in-home care, I don't know, it's appropriate in this person's circumstances. It's got to be a forward-facing examination. So if they utilize long-term institutionalization for a period and we're able to get other resources to get care, that is, something that the agency has to consider. So, yeah. Any other questions that we have, or did we finish super early and I can let folks go early? So I just want folks to know, I don't know if there are any other questions. I know I had some questions about accessing public benefits, and which is a separate training. And so if that person who had put in, feel free to put your as when we close out this webinar, there should be an evaluation form. Please feel free to put your information in there, and we can figure out a way to respond to that. Okay, so here's a question. If somebody who's undocumented who wants to apply for VAWA and has had assistance, would public charge be considered? So if the person is undocumented and they're applying under VAWA, And so if we're thinking of that person as a self-petitioner, meaning they are either married to a U.S. citizen or permanent resident, or their parent is a U.S. citizen or permanent resident, and they're a victim of abuse, and they've been able to, generally, most undocumented people are not eligible for some kind of public benefits that would count. So this is, I'm trying to figure out a circumstance in which that would actually apply to them. So somebody who's undocumented, I mean, maybe there's a state cash assistance program. If there's a state income, type cash assistance program that's funded by the state for an undocumented person. If they're applying for VAWA and they, there would not be a public, if they actually qualify for VAWA and they, have self-petitioned, the public charge test would not apply to them, and neither would receipt of their benefits. So I think that's okay. Oh, or they applied for TANF through their documented children and later they find out they qualify. No. So in that circumstances, their children, their children are the beneficiaries. They are not even eligible for that benefits program. And so yes, make that very clear. And this is actually a very common scenario. So somebody who's applied for TANF for their kids because their kids are qualified, encourage them to do that. The public charge test does not, that's not going to use by their kids, their family members, others that live in their household doesn't apply. That is not considered when they're going to apply for permanent residence or applying for status. And then if they're applying under VAWA as a self-petitioner, public charge doesn't even apply to that at all. So they're exempt. So from the public charge test. So yes. Any other questions while I am still on and before we close out? So yes, this person's safe, at least as it relates to the public charge rule, and hopefully in other ways as well. But yes, the benefits used by kids that are not seeking status are not to be considered. I mean, if the kids later are applying for status themselves and they're not U.S. citizens, then, and they're not applying under an exempt category. So look at the boxes of exempt categories. If they're not applying for one of those statuses, then they, if they're not applying under one of those exempt statuses, it might possibly apply to them in the future. But yeah, the question is like when somebody goes to do their immigration interview, they want to figure out, are you in an exempt category? And if you're in an exempt category, it doesn't matter. Like any use of benefits in the past doesn't matter. If you're not in an exempt category, the immigration examiner has to look at the whole series of circumstances. They want to look at your age, they want to look at your income, they want to look at your family status, they want to look at, your health, all of those things. And they have to decide in the future, even if you receive benefits way in the past, they have to decide if in the future you are likely to become primarily dependent on the government for subsistence. And so, meaning that they think that at that time when they're interviewing you, that you're likely to become dependent on, cash assistance and or long-term institutional care. And so like if usage of benefits was way in the past and the person has evidence of all sorts of other things that would show they're not likely to become primarily dependent on the government. And so primarily dependent, means that you don't have other sources of income or support like other family members or, some part-time pay, etc., then at that moment in time, if they think you're likely to become primarily dependent, then they could deny you. But so many survivors may be in an exempt category, or they used benefits while they were in an exempt category, or it was their children or family members that used the benefits and not them, or it was a type of benefit that doesn't count, like food or medical, that that's not for institutionalization or housing, et cetera, or it was, an emergency program, those are, or unemployment compensation, those are all benefits that shouldn't count or not be considered, or should not be considered. So, I mean, a lot of people are just like knocked out of the public charge determination, or the, benefits they've used are knocked out of the determination. So we just can't impress on folks enough, especially for survivors, because we know how important all of these benefits are to help people overcome escape abuse. And that's one of the things we, are pushing for as we're going on and talking with the agency, is that, we want them to give guidance to the adjudicators about how how important it is for benefits and supports for survivors to be able to overcome and escape abuse. And once, survivors get on their feet, if they can get status, and we keep trying to tell them, if you give them their green card, they'll be able to work, they'll be able to like support themselves. Like that's part of the point, is being able to, become independent. And so like, that's just one of those points of advocacy that we continue to work with the agency on, and hope we get better guidance, or, more supportive guidance of survivors as we go along. So yeah, I think we're done early. Yeah. And if, I encourage you to complete the evaluation, and if you have specific questions, like that you raised, that like I really are off the topic of this, I can either put your contact information in so we can respond to you. Okay. All right. Any other? Yeah, here's the QR code, and or the survey evaluation information is in the chat.
Thank you, Grace. It looks like there's no other questions. I'm just going to leave this up a couple more moments for people who want to scan the QR code. And then I will be sending a follow-up email through Zoom with all with the slides and the links and various things. So if you do have questions that come up later, please use the email that you see here to get in contact with us. And I hope you have a good rest of your day.